Hello. For our preliminary examination, I shall be discussing two among the given topics. I shall be discussing three constitutional limitations and the procedure on tax assessment. I shall now discuss the procedures on tax assessment. I shall first establish that the nature of internal revenue taxes is self-assessing. Self-assessing means that the taxpayer himself has the responsibility of computing, of filing, and of paying his taxes to the Bureau of Internal Revenue, or to the BIR. This is what we call self-assessment. Now, what is tax assessment as used in tax code? Tax assessment as used in tax code involves the following. First, the determination of the correctness of tax due in accordance with the prevailing tax laws. And next, giving a written notice to the taxpayer of the findings. And finally, issuing a demand for the payment of the liabilities of the taxpayer or any deficiency that he has. Let us now go over the requisites of a valid assessment. First, between the tax official and the taxpayer, there must be no agreement prior to the assessment. Next, there must be a written notice. The findings must be in writing. And finally, it must state the facts, the law, the rules, the regulations, and the jurisprudence upon which the assessment has been made. The assessment is made or issued based on the findings on fact or law by the revenue officer. Now, what if there is a finding of deficiency? When there's a finding of deficiency, we now shall have what we call a prospective assessment. A prospective assessment. In a prospective assessment, a preliminary assessment notice, or PAN, shall be given to the taxpayer. In the preliminary assessment notice, it shall state there the facts, the law, the rules, the regulations, and the jurisprudence upon which the assessment has been made. And it is important, this preliminary assessment notice is important in the process on the issuance of a deficiency tax assessment. Now, what can a taxpayer do if he receives a PAN? A PAN, or preliminary assessment notice, not a pan of bread. So what can the taxpayer do? The taxpayer has the right to 15 days, a time of 15 days in which he may explain his side. He shall be given the right to be heard. Now, what if within 15 days we do not hear from the taxpayer does not explain his side? The taxpayer shall then be considered in default. Now that he is in default, he shall be given an FLD and a FAN, not an electric fan. FLD stands for Formal Letter of Demand, and FAN stands for Final Assessment Notice. The FLD and the FAN is issued to the taxpayer to demand for the payment of his tax liabilities and applicable penalties. Upon receipt of the FLD and the FAN, what can a taxpayer do? The taxpayer has a right to a disputed assessment, wherein the taxpayer may file a protest on questioning the validity and legality of the assessment, and he may also ask for cancellation. The taxpayer may file a protest within 30 days upon receipt of the notice, and he may ask for either a request for reconsideration and a request for reinvestigation. What's in a motion for reconsideration? First, it is a request or for a review. The taxpayer may request the BIR to review his existing documents, and there is no need for a supporting documents in the motion for reconsideration. Meanwhile, in the motion for reinvestigation, the taxpayer may request the BIR to have a second look at his documents. And the BIR may also look at the additional documents that the taxpayer shall provide. And this additional document must be provided by the taxpayer within 60 days upon filing his protest. Now, what if the taxpayer does not provide additional documents? What happens then? Well, according to the law, the assessment becomes a final assessment. But what is a final assessment? A final assessment is an official assessment that has not been disputed. it has not been properly appealed within the given time, and the assessment becomes final, executory, and demandable. Now that's sad. What can a taxpayer do then? Well, the taxpayer can appeal to the Court of Tax Appeals. See, the BIR shall deny the taxpayer of his right to protest. He cannot protest anymore. There's no more chance. And now that the taxpayer has been denied by the BIR to protest and provide supporting documents, the taxpayer may then appeal to the Court of Tax Appeals within 30 days upon receipt of the denial, or from the lapse of the 180-day period. And from that 180-day period, the BIR shall ignore any supporting documents. Now, what if the taxpayer does not appeal within the given time? Now, the assessment shall then become final, executory, and demandable. It's legit this time. Shall become demandable. Now, I've mentioned earlier 2 ways to file a protest, to dispute an assessment, to contest the validity of the assessment. And there are 2 more ways in questioning the validity of the tax assessment. And first, we have the motion for withdrawal, wherein the taxpayer may request for the BIR or the CTA, the Court of Tax Appeals, to remove a tax fee bargain, an agreement which the taxpayer has entered in because he has been pressured to do so. And finally, the motion for cancellation. The taxpayer may request the BIR and the CTA to stop the tax assessment, to cancel the tax assessment due to prescription and violation of the due process of law. Okay, I shall first discuss 3 constitutional limitations. There are 12 constitutional limitations on the power of the state to tax. First, we have the due process of law. Second, we have the equal protection of law. Third, we have the uniformity and equity in treatment. Fourth, we have prohibition against imprisonment for non-payment of all tax. Fifth, we have prohibition on or against the impairment of contracts. Sixth, we have the origination of the revenue bills. Seventh, we have limitations on matters related to religious purposes. Next, we have exemption of property, the collection of property taxes on religious, charitable, and educational institutions. Next, we have the president's veto power. Next, we have the taxes as the general funds of the government. And next, we have the Congress grant to taxation. And last, we have the power of judicial review. Yay! And I shall be discussing 3. First, I shall be discussing the president's veto power. Next, the origination of the revenue bills. And last is the exemption of property taxes on certain institutions. First, the president's veto power. The Constitution provides that every bill passed by the Congress before it becomes a law shall be passed to the president. Now, if the president approves the bill, he shall sign it, and then it shall become a law. But if he does not approve the bill, he shall veto it, and then return it with his objections in a journal and proceed to reconsider it. Now, we can define veto power as the executive power to refuse to sign a bill that has been passed by the legislature, and it can be classified into 2: an item veto power and a pocket veto power. The item veto power is the power to veto items in an appropriation bill without affecting the other provisions of such bills, while the pocket veto power is the disapproval of the bill by inaction of the president, which shall cause the bill to fail to become a law. Now, under the Constitution, the president does not have the so-called pocket veto power because his failure to communicate his veto of a bill that has been passed to him within 30 days shall automatically cause the bill to become a law. If the president vetoed a bill, then 2/3 of the members of the House shall be required so that the bill can be passed into a law. Now, for instance, if the Congress passes to the president a bill regarding the agricultural sector, if the president approves the bill, he shall sign it. But if there are certain items that he does not approve, he may practice the item veto power to disapprove certain items in the appropriation bill. Now, let's say within 30 days since the Congress has passed this appropriation bill on agriculture, the bill shall automatically become a law without the response of the president. If he vetoes it or not, if he approves it or not, it shall automatically become a law. Now, for the second constitutional limitation that I will be discussing, I shall discuss the exemption from property taxation of entities with religious, charitable, and educational purposes. What is important to remember is that these properties used by these particular institutions must be actually directly and exclusively used for their purposes. And it must also be noted that property taxation, the basis of property taxation is not the ownership of the property, but the use of the property. So for instance, let's say there is a 50 square kilometer of a property owned by the Catholic Church. And like 1/4 of that property is being used by businesses. Let's say there are certain stalls selling lugaw, champorado, and pansit. And who is taxed? From whom do we collect property taxes? Do we collect it from the Catholic Church because they own the property, the 50 square kilometer property? Or do we collect it from the businesses who use that 1/4 part of the property? Of course, we collect it from the businesses who are using that 1/4 part of the property because they are the ones who use it, even though they are not the ones who actually own it. Now, any other part that is actually directly exclusively used for the purposes of religion, of charity, and education shall not be taxed or shall not be collected. Any part of the property that is actually directly and exclusively used for the purposes of religion, charity, and education shall not be taxed. In terms of property taxation, now we also have the non-stock, non-profit educational institutions. These are also tax exempt in terms of income taxes, provided that their purposes are actually and directly and exclusively for education. Any other activities that are not related to this purpose, or not actually, not directly, not exclusively for this purpose, is taxable. Now, for the third constitutional limitation, I shall discuss the origination of appropriation, revenue, and tariff bills. Tax laws are imposed by the legislative branch, or the Congress, which is composed of two houses, the upper house or the Senate, and the lower house, which is the House of Representatives. Tama. And it is provided in the Constitution that all appropriation and revenue bills shall originate exclusively from the House of Representatives. However, the Senate may provide amendments or they may draft their own version of the appropriation bills. The reason for this is that theoretically, the House of Representatives or the lower house is expected to be more sensitive to the needs and demands of the public. The House of Representatives are elected from the districts. So they are the representatives of the local people and they are expected to take initiatives regarding bills that address the local problems. Now, the Senate may provide their amendments or they may draft their versions of these bills. But what is important is that the initiative must come from the House of Representatives. So, for instance, an appropriation bill for the funds of the agricultural sector. So it is important that since it is an appropriation bill, it must come or it must originate from the House of Representatives. However, while the bill is in the process of hearing, the Senate may provide their amendments. They may also write their own version. Now, if the bill has been passed into a law and the final version is from the version that has been drafted by the Senate or from the amendment by the Senate, it is still valid as long as the bill has been originated from the House of Representatives.